For the appellant, will there be one argument or just will it be more than one?
I have drawn the short straw, Your Honor, and so they're gonna cheer me on.
Okay.
Just me, and I would like, if I say it now, I'd like to reserve 5 minutes.
You sure can. Thank you. You may proceed.
Yes, sir. Good afternoon, Your Honors. Rachel Hurt here on behalf of Defendants Methodist Medical Center and Covenant Health. Also sitting at counsel's table is Sydney Gilbert here on behalf of Dr. Cox, and Ted White here on behalf of Dr. Justice and Parkway Cardiology Associates. Your Honors, I have prepared probably 39 minutes of materials. I'm happy to start in with my recitation of what I want to say, but I also know that this court often has things that they want to talk about as well. And so I'll ask the court, would you like me to start on my argument, or would you like to proceed with questions of significance to you?
You said you prepared 39 minutes.
I did. I understand I've got about 9.5 and probably about 9 left, but...
I would say start wherever you can start to not get 39 minutes in.
Very good. Then I will skip the facts and I will go into my legal arguments, interdispersing the facts as I feel relevant. First, let me just briefly say, as a quick side note, or a quick issue, the standard of review in this case is de novo. It is entirely a question of law. In plaintiff's brief, there is a suggestion or an indication that it is a mixed question, but in fact the mixed question only comes into play if there's extraordinary cause being asserted. Myers is very clear on that, and there is no assertion here by the plaintiffs of extraordinary cause. I'm a healthcare liability attorney. I have been so for 15 years, but I'm not going to start with the Healthcare Liability Act. I want to start in family law. I want to start on the issue of standing, if I may.
All right. Either way.
Okay. This issue comes down to who is the proper person to bring this lawsuit, who is the claimant, and the relationship of that claimant. And that is the language from the Healthcare Liability Act. But this issue comes down to, did we receive proper pre-suit notice? And the answer is simply, on family law, no. Bobbie Jo Denson is a temporary custodian. She is not the guardian. There are still 2 fathers in this picture who have rights in this case. They are the next of kin to these children. The temporary adjudicatory order that's in the record that is at issue in this case clearly states that Bobbie Jo Denson is the custodian. And that's important because she's not the guardian. And the guardian would have given her rights, would have allowed her to be an authorized agent under the language of 29, 26, 121, A1, to be the authorized agent to give notice of a potential healthcare liability claim. But she is not the authorized agent under the law, not under the guardian statutes, not under the custodian statutes of the state of Tennessee, not under the adjudicatory order of the juvenile court. It expressly limits what she can and can't do, and those limitations in that order do not, or the rights of that order, do not permit her to file lawsuits on behalf of the minor children. And that,
Ms. Hurt, let me ask you this,
Yes,
and you're kind of hitting on one of my questions, which is, if she didn't have standing, who did? And is it your position it would be one of the 2 fathers, or could grandmother have petitioned the court to have herself established as a guardian and therefore gotten standing that way?
under the facts before this court, there is a guardian ad litem, Amanda McCullough. There are 2 fathers whose rights have not been terminated under the facts of this court, and she is a legal custodian. She could have moved the court to become the guardian, but there was a guardian in place already. The adjudicatory order makes that clear. But because she never moved, and also it kind of comes into play under 1703, an argument, Rule of Civil Procedure 1703 of next of kin, she's also not next of kin. The fathers are still there. They still have rights. The fathers have not been brought into this lawsuit. They've not, to our knowledge, been made aware of this lawsuit. They are next of kin. And so as we stand, Bobbie Jo Denson does not have standing, not only to file this suit, she did not have a right to give pre-suit notice. Now, the significance of that is it all comes down, for once, a defense attorney is not trying to expand the language of the Healthcare Liability Act. We're only asking for the rights that are expressly enumerated under it. And the statute expressly states under subsection A, the person who is filing or asserting a potential cause of action, or that authorized agent of that person. That's under A1. And under A2, it says the name and the address of the claimant in the relationship of same. You can put, a plaintiff attorney can put anything in the notice they want, but the legislature demanded that 9 things be included. And one of those 9 was the relationship of the claimant. And nowhere in the notice does it say the relationship of the claimant, because the claimants are the minor children. And it never says that the minor children are bringing a cause of action. The notice makes no reference to Bobbie Jo Denson as being the legal guardian, because she is not. It makes no statement that she is filing of next of kin, because she is not. It makes not even an assertion that she is giving this notice as the custodian. It makes no mention of the minor children at all. And therefore, looking at Martin versus Rolling Hills, Tennessee Supreme Court opinion by my favorite justice, Justice Clark, she expressly states why it matters, that relationship. She says that the purposes of A, B, and C of subsection 121A2, but the 3 things that must be known is who the plaintiff is, how to contact them, and how to consider, or how to reach the plaintiff attorney to consider early resolution. What plaintiff is asking is to say, it doesn't matter who gives notice. Someone gave notice, you knew it was a lawsuit, but it does matter for this reason. Let's say that if anybody can give notice, defense attorney contacts plaintiff counsel, says, hey, we want to try to settle this case. Okay, you've given me notice. I want to settle with Bobbie Jo Denson. We settle with Bobbie Jo Denson. Minor child's father files suit in court and says, actually, I'm next of kin. Bobbie Jo Denson had no right to assert a cause of action of these minor children. So you may have settled with her, but she has no right to waive the claims of the minor children, because they're the minor children's claims. Justice Kirby expressly says that in Beard. And so to have this holding go forward, that it doesn't matter who gives notice, which is what Judge Spitzer found, respect him to death. But what he assumed is that Bobbie Jo Denson had to be the person who had the right. But he never found that she was the person who had the right, because she doesn't. Because nothing under the statutes, the facts before the case, or the adjudicatory order give her the right to be the person with standing to file this lawsuit, or with authority to assert a claim on behalf of the minor children. And so because there was no right on behalf of Bobbie Jo Denson, under strict compliance, the minor plaintiffs never even attempted to give us notice. That is enough right there to say under strict compliance, this case should be dismissed. But if we get to the next layer, if we get to substantial compliance, I say first, as I've already said, there was no identification of the relationship of the minor children to Ms. Denson. And why did the legislature say that relationship mattered? Why did it say? Because the purpose of the intent of the legislature in passing the pre-suit notice was to encourage early resolution. And so, as I've said, you have to know who you can settle with. You have to know the relationship, because it matters to who is going to sign the release. And so one of the 9 criteria we were not given. And looking at the Martin case and what it says about prejudice, Martin, Justice Clark, the Supreme Court said, when you look at prejudice, were you denied a benefit of the statute? A benefit of the statute is expressly stated as the relationship. And so defendants respectfully argue we were denied a benefit. What is the impact of that benefit? Why does relationship matter? Well, at the most basic point, it matters to the value of the case. Under 2939 102C, the value of the case of a minor child in a wrongful death is $1 million. But if it's the mother's suit, it's $750,000. And so we were denied the right of knowing the value, the potential max exposure of the value of the case. What else were we denied? We were denied the right to attempt settlement with the proper plaintiff. We were denied that right by not knowing. We were denied the right of knowing the relationship of who might bring this suit and how that impacts litigation. We know it impacts litigation in the overwhelming significance of empathy and sympathy. A single woman who was unmarried, who had no children, who had no job, who had underlying health conditions is entirely different than a mother of 2 minor children. Sympathy absolutely matters, and it has been brought up in every step of this case, the fact that the minor children lost their mother. So we know that sympathy matters. I was thinking there were going to be more questions. I will sit down now. Thank you.
I hear you. Thank you.
Please, the court.
Yes, sir.
I'm Tim Holton, and I represent the Denson family. I think we have to look at this in a little bit different perspective. This is a situation where a 32-year-old mother of 2 died suddenly, had a heart attack is what happened at the hospital. And the grandmother is now in a position where she's got to raise 2 kids under the age of 12. I'm not trying for sympathy here, I'm just stating a fact.
Sure.
So this grandmother is dealing with a situation where she has 2 kids that she now has to raise. The issue of the 2 fathers, if if the court will recall, if you look through the juvenile court materials, no fathers appeared at the hearings after the death of the mother. No one showed up. Nobody did anything about it.
But does that mean that they don't have rights?
Well,
If their rights weren't terminated, they still have a right to bring an action on behalf of their children, don't they?
Well, they do, but possibly. But here's the issue. The first thing you got to do is give notice. Those 2 fathers can't provide a HIPAA release to give notice. They've got no relationship with the dead lady, with the mother. They're not her husband. They can't sign it. The only person on the face of the earth that could sign the HIPAA release was the grandmother. And a death certificate was attached to establish that she was signing it as, the mother of the decedent. She also happened to be the person, as is shown in the medical records, who had to make the decision to turn off the machines when it came time for her daughter to die. So she made those decisions.
What, if any, rights that and authority that the guardianship gave to the grandmother?
The guardianship, the temporary, it's now not temporary, obviously, it's permanent, that she had custody, was the custodian of the children. And so by virtue of Rule 17, as a custodian, she can bring a cause of action on behalf of the 2 children of which she is the custodian. That's stated in Rule 17. The issue goes back again, though, what were the defendants denied? They know, remembering again, this is a wrongful death action. So under the statute, there's no requirement in a wrongful death action that you list all the beneficiaries when you say who is bringing this action. You don't do that. It would be impossible, number one, because as the court knows, in many instances, all the heirs have not been determined. That would happen later on through a probate court if there were any issues. God forbid if the children died during this period of time, then the grandmother would be the only survivor. She would have the only cause of action. So the defendants were given, under the circumstances of this case, the only notice they could have been. They were provided with a HIPAA release. They got the medical records, no doubt about it. And counsel is the person who drew the conclusions from the medical record.
Grandmother is not a beneficiary, is she?
I'm sorry?
Grandmother was not a beneficiary, though, was she?
At this point, she was not, but if the children die, she would be. If the children, God forbid, something happened to them, grandmother would be the person, the beneficiary. So at this point, again, looking at the purpose of the notice, you want to find out what the malpractice was, who was involved, and that you may be sued. The statute does not say all beneficiaries. It doesn't mention beneficiaries at all. So there's no distinction drawn that in a wrongful death case you got to list every potential beneficiary. That's not required. But again, the defendants had all the information they needed. They knew who the decedent was. They knew why their claim would be brought because of failure to diagnose a heart attack. They knew that she was 32 years old, childbearing age. She had had 2 cesarean sections.
Well, that information is information they would have had to have discovered upon reviewing
her records. I mean, the point of the pre-suit notice requirement is to give all of the relevant information necessary for evaluating the claim early in the litigation. And what they're saying is, based on this notice, we had no idea that the two actual, not beneficiaries, but people holding the claim are the children. And it does change the financial evaluation of the case, does it not?
It does change the financial evaluation of the case, but we have to consider, does this notice give you everything you need, or is there an independent obligation of counsel to research? Because by way of example, if the case, it was simply a wrongful death, and the estate brought the action, the estate's not been probated, we don't know how many heirs you have, all we know is a 32-year-old decedent, and attorney such and such represents the estate. That would be all they know. That's no different than this situation. It doesn't list who the kids are. It would just say Tim Holton as the representative of the estate of the decedent. That's all the information they would have. So they have what information they would have gotten normally. If it bears research, all they would have had to do was Google the lady's name, and the first thing it says in her obituary is a mother of 2 children, and lists the name of the kids. So it's not anything was hidden from them, but the situation in this case is dealing with a wrongful death action, and had an estate been opened, had I or someone, gone down there, been appointed to represent the estate, they would have no more knowledge whatsoever than what they had in this situation. They would simply have the estate. Because the estate hasn't been probated, we don't know who the heirs are. There may be other children. We don't know that at this point. So you would just have Timothy Holton representing the estate of the decedent. There's no difference here. These children had no other vehicle by which to commence the lawsuit, and no one to do it. The 2 fathers had no involvement, and they certainly couldn't give the notice that was required. The children are 12 years old and under. They can't sign anything, as the courts have recognized.
What about the guardian ad litem?
The guardian ad litem would have no authority to sign and bring a claim to authorize the issue, the HIPAA notice. They have no relationship to the decedent. That's the problem. We're dealing with a situation where the cause of action is for the decedent. Okay? It's not the pain and suffering of the children. It's the decedent. And when she died, that cause of action was brought for her beneficiaries, which at present are the 2 children. But that's not a stagnant concept. That can change. If the children, God forbid, die, then it is only grandma that I'm aware of. There may be someone else. There is no husband. There's no father involved with these children. So we're left in a situation where the only person that could give notice, which is the most important thing, and to give the HIPAA release, which is the basis of the whole statute, so they can know ahead of time, what did we do wrong and who did we do it to? You didn't do it to the children. They're not the people that were harmed. The person who was harmed was Ashley Denson, the mother, the decedent. And that's who they were provided notice of at potential cause of action for what occurred when she was at their hospital on that day. And they had all that notice. I think the issue becomes confused when you think of the difference if a lawsuit were brought and it was not a wrongful death action. But in a wrongful death action, this could have been brought by an attorney representing the estate, and the decedent or the defendants would have no knowledge whatsoever who the beneficiaries were. Because once that estate is open, then there's publication, there's time for things to come in. That wouldn't give them any knowledge. The knowledge that was in the medical records, which I think the trial court correctly found they were not prejudiced. They knew she was 32 years old, divorced. When it said go see your doctor the next day, the doctor that she was going to see was an OBGYN. And she had 2 prior cesarean sections. So any defendant counsel looking at that would know, this sounds like a lady who might have kids. She had 2 cesarean sections. You don't do those operations unless you're pregnant and having a baby. And that's what this lady did.
You do know that people see OBGYNs for reasons other than taking
Yes, ma'am.
babies.
They don't. The cesarean section, which is what I was referring to.
Gotcha.
There's only one reason you do that. that's if you have children. And all of that information was in the record, as well as the fact that she was accompanied by her family who remained at her bedside. So she was not a spinster, person with no family at the hospital with bad health. She was a 32-year-old woman with her family who had 2 prior cesarean sections, who unfortunately died as a result of the medical negligence that occurred. But I would submit to the court, in this scenario, there is no one else that could give notice, and the defendants would have no more information had an estate been opened and an attorney brought it than what they got when they received the notice indicating that a lawsuit may be filed resulting as a result of the death of Ashley Denson at your facility on this particular day. And they obtained the records and that information. Unfortunately, their assessment of those medical records is what misled them as to the potential value of the case.
The pre-suit notice was filed, and that's what our problem today. What about the complaint? Was the complaint ever filed on this case?
Yes, sir. The complaint was filed.
What did the complaint say?
The complaint was filed by a next friend of the children, the grandmother, on behalf of the children as next friend. And that was how it was filed. So that hasn't changed. The issue is, simply the pre-suit notice, and did they have the information that they should have had? And I would submit, based on what the medical record contained and the conclusions that they drew, I think the issue was they read the records with an eye that mistook several of the facts that were there for them to review. Thank you.
Your Honor, I want to correct a few what I believe to be misstatements of what have just been said. First, in the adjudicatory hearing order, it expressly states that there is an attorney who appears for one of the fathers. One of the fathers had representation there. The court specifically found that that father did not neglect the child or make the child dependent. And so it's not true to say that both fathers did not attend and have neglected these children. Secondly, I want to clarify that the caption says Bobbie Jo Denson individually and as next friend of Ashley Denson. It makes no reference to the minor children. And in fact, the only paragraph in the complaint that mentions the children says that Bobbie Jo Denson is the legal guardian. Of course, in the course of this litigation, plaintiff has walked away from the fact that individually she had a right cause of action because she doesn't under the wrongful death statute. She's walked away from the fact that she is the legal guardian because she is not. She's had to walk away from the fact that she is next of kin because she is not. But I want to focus right now on the assertion that the inference drawn from the medical records was incorrect. First, it misses the point that if the notice statute had been followed, as it expressly stated, no inference would needed to have been drawn. There would have been no reliance on counsel, or actually more importantly, the defendant. It's not what counsel infers from the medical record, it's what the defendant knows. It's to put the defendant on notice, not defendant's counsel. And so the defendant in this case, Methodist Medical Center of Oak Ridge and Covenant Health, and equally has been said by all defendants in this case, did not know that that Ashley Denson had children still in her custody at the time of her death. And nothing in the medical record states that. There is no inference to be drawn that that is the case. In fact, the inference is she was with family. She was with her mother and her boyfriend. And my clients, the defendants, knew that because Ashley Denson was in the ER with my providers. And so they did not know of children because children were not in the ER. And so that was an inference that she was single, she had a boyfriend, she had a mother. But most importantly, the inferences that were drawn is because the notice itself did not mention minor children. And so when we're reading the 7,148 pages in this case, the mind has already known that they've identified the mother as the next friend of a daughter where no children are mentioned. And so an inference is not a reason to punish defendants because an inference never should have been needed in this case. Next, plaintiff talks about Rule 17, and he's referring to Rule 1703, that does state that if you have the appropriate designation, that you may bring a cause of action on behalf of minor children. Importantly, the word custodian is nowhere mentioned in Rule 1703. It does not mention custodian. It mentions a guardian and a conservator, but it does not say custodian. It next says if you're not the proper designation, you can bring as next of kin. We've already discussed she's not next of kin. But even if she was next of kin, the very next sentence says the judge, the trial court, should then, after the filing, appoint a guardian ad litem. She had a guardian ad litem. The minor children had a guardian ad litem. They had someone to bring this lawsuit to properly give notice. And so when plaintiff makes the argument that we had, quote, everything that we needed, the one thing we didn't have was the proper plaintiff. The one thing we didn't have was the proper claimant, and nothing in the medical records and nothing in the notice ever gave us that information. So we didn't have everything. And it's incorrect to conflate plaintiff and beneficiary as if they're the same. If we had a proper plaintiff, I agree. We don't have an argument, and we wouldn't be here today. But we didn't have the plaintiff, and the plaintiff mattered in this case. It affected the value of the case. It affected the case. And so it's incorrect and inaccurate to say that the defendants had everything, because we didn't have a proper plaintiff, and we were never given pre-suit notice of that, and we were prejudiced as a result of not knowing the proper plaintiff, and under strict compliance, under A1, the plaintiff, the proper plaintiff, the person who can assert a cause of action, never gave any defendant pre-suit notice. Unless there's any other questions, I'll yield my 16 seconds.
I hear none.
Thank you very much, sir.
Thank both counsel for your presentation. Your case has now been submitted to this court for resolution.